Okay, so we're going to give it another minute, but while we wait for some more people to join us, I just wanted to welcome everyone that's here right now. And thank you for joining us today as we discuss the upcoming changes to the Community Medicaid program. My name is Deirdre Baker. I'm an attorney with the Makovsky Law Group. We're located in Garden City, New York. We're also very lucky today to be joined by Nicole Christensen of Care Answered. She is a healthcare coordinator and advocate. I will be discussing the financial changes to the Medicaid program, and Nicole will be discussing the upcoming increased standards and the changes to the assessments once someone is approved for Medicaid. So I think most people that are going to join us are probably here, so I'm going to get started. So New York has traditionally had a very generous home care Medicaid program. And for those of you who don't know, Medicaid is a federally funded program, and each state gets its own budget, and they utilize that budget according to its own rules and regulations. So because of that generosity that New York State has always utilized for its services, every year when New York is working on its budget, there are always proposed or threatened cuts and changes to the program. In the April 2020 budget, Medicaid finally made good on some of these changes. And the biggest change, the change that's going to affect the most people, is a new 2.5-year or 30-month look-back period for the home care Medicaid program. Up until now, there's never been a look-back period for the home care Medicaid program. The only program that had a look-back period assessed was the nursing home program. These changes were supposed to go into effect October 1st, 2020. It was then pushed back to January 1st of this year, was again pushed back till April 1st of this year. And there's some rumors, it looks like the look back period will not go into effect until July 1st, 2021. Part of the reason these delays keep happening are really twofold. One, because of the ongoing coronavirus pandemic, there are federal regulations that say when someone's receiving services and benefits, changes can't be made while this pandemic is ongoing. But really, I think the bigger reason that these changes haven't gone into effect is that the Department of Health hasn't really created and prepared the new forms and assessment tools that are going to be used once these changes go into effect. And essentially what the look back period means is that for gifts or transfers made during the applicable time frame, there's going to be a penalty period assessed for new applicants. What we do know is that for people who are applying today, they will be assessed under the current application rules and regulations. So here are some basic rules for someone who's applying today. There is a $15,900 resource allowance, which basically means money in your bank accounts, but assets are treated a little bit differently. So we will discuss them in a little bit, the differences. There's also a Medicaid allowance that is imposed. So for individuals who are applying and they're over the age of 65, Medicaid will disregard or allow them to keep $904 per month of their income. And there's also a credit or a deduction for health insurance premiums. Anything over and above that will be considered surplus or excess income, and we will discuss some options that applicants have when they have too much income. But the most important thing is that for individuals applying today before the look back period goes into effect, there are no penalty periods assessed for transfers made before you make a home care Medicaid application. So, sorry about that. So if you were coming into my office today and you were, or a loved one were in need of home care services, this is the very basic process for becoming eligible and for starting to get services on the Medicaid program. The first and most important step is the applicant must be financially eligible at the time they are applying. So if someone came into my office today, February 11th, we would be taking a look at what their assets are and determining what needs to happen in order to make them financially eligible. So non-exempt assets that are over $15,900 must be transferred out of that applicant's name. Medicaid eligibility is determined on a month-to-month basis. So even though that person wouldn't be eligible today, if they were able to make the necessary transfers by the end of the month, they would be financially eligible to apply for Medicaid as of March 1st, 2021. We also have to make an assessment regarding their income. So for most people living in New York State, they have income over and above the $904 allowance. And even when we factor in their out-of-pocket health insurance premiums, very often they still have income over and above that. Medicaid basically gives you 3 different options for dealing with your surplus or your excess income. The first option is you can send it to Medicaid as a contribution towards your care. They love that. They're happy to take your money. But for most people, that's really not feasible because they need all of their income to maintain themselves in the community, pay their rent, their mortgage, their property taxes, groceries, things like that. The second option is if you have a lot of out-of-pocket medical expenses, services or therapies, equipment that's not covered by your insurance, you can submit proof of that to Medicaid, and they will reduce your surplus income. Again, this isn't very common. Most people have insurance that covers their basic health insurance needs. So the third option, the most common option, is the establishment of a pooled income trust, which really works like a separate bank account that's established for the benefit of the applicant. And the income goes in there every month. And from there, the income continues to be available to pay all of your expenses and pay all of your bills. So very often when we're getting an application together, when we're getting someone eligible, it involves creating and funding a pooled income trust. So once an applicant is under the resource allowance, they have a pooled trust if necessary, and we've signed all the application forms and authorizations. We then take that and submit it to the appropriate county because each county basically has its own Medicaid office, and that's where you apply based on where you live. So once you are deemed approved by Medicaid, you then have to be evaluated to determine how many hours you're going to be receiving. I'm not going to spend too much time on this because I know Nicole is going to discuss this in depth. But essentially, once you've been approved, there are 2 assessments or evaluations that take place. The first is through New York State Department of Health, and the second is through generally a managed long-term care plan that is actually going to be the one administering your care, and they'll be the ones determining or recommending how many hours of care they think you need. So I want to circle back for 1 second. I mentioned earlier that assets are all not treated the same. So when we're determining whether or not someone is financially eligible for Medicaid, it's not just looking at their total resources and seeing whether or not those are less than $15,900. We have to look at how assets are titled, the type of accounts that they have in order to really make an assessment. So the non-exempt resources, the type of assets that Medicaid is looking at, are things like your regular bank accounts. Anything you own joint with another person is always going to be considered non-exempt. If you have life insurance that has a cash value, if you own individual stocks or bonds, those are the types of things that Medicaid is looking for when they're assessing whether or not you're eligible. The good thing is that not all assets are considered non-exempt. So some of the most common exempt resources are the value of your primary residence, your retirement accounts, so things like 401k, a traditional IRA, anything that grows tax deferred will be considered exempt. And for many individuals, this is a bulk of their liquid assets. What Medicaid will do regarding your retirement accounts is count your income, your required minimum distributions, as part of your income assessment. But the balance, the principal of that account will be exempt, meaning Medicaid can't force you to utilize that asset to pay for your own care. And if you have prepaid your own funeral, if you have a prepaid burial fund or trust, the value of that asset is also not considered as available to you or considered non-exempt. So with these new regulations that are going into effect, there's not 100% clarity on every aspect of the application process, but here are some things that we do know. Applications made after as early as April 1st will be assessed a phased-in look-back period, which basically means that the first month the look-back period will go into effect, The look back period is not going to be 2.5 years right away. Medicaid will add on a month of the look back as time goes on. So while this is good news that the look back period won't be 2.5 years at the outside, it's still a good idea to start thinking of applying if you or a loved one is in need of care or you're on the fence, because we don't really know what the application process will look like once all of these rules go into effect. We do know that the resource allowance of $15,900 will remain the same. And we do know that any gifts or transfers made during the applicable look back period, whatever look back period is in effect at the time of your application, will result in a penalty period. And a penalty period is basically a portion or length of time where the applicant will be responsible for paying for his own care or her own care out of pocket. And as you can imagine, this can get really expensive. So how does Medicaid assess or calculate this penalty period? For something like nursing home care, it's relatively straightforward and we know exactly what that process looks like. The look back period is a length of time where Medicaid is going to require the applicant to submit financial records. The caseworker will then review every page of every financial statement and circle or highlight problematic transfers that they find during their review. And they'll put those transactions off to the side. Once they've conducted the thorough review, they've gone through every bank statement, every tax return, they'll total up all of the problematic gifts or transfers, things that can't be explained and things that can't be proven to be for the benefit of the applicant. They'll take that amount of money and they'll divide it for nursing home care by the average cost of the nursing home in the county where you live. And the resulting figure is the length of time where you will be responsible for paying for your own care. The penalty period doesn't start running or doesn't start being assessed until you're otherwise eligible, meaning your assets are below $15,900. You're actually in need of services. So if you make a transfer today, but you're perfectly healthy, your penalty period hasn't started running, unfortunately. And 3, you've actually applied for Medicaid. They've approved you, but they've assessed this penalty period. So those are really the main components there. If you make a transfer today, like I said, but you're not in need of care, you're really not doing anything to benefit yourself in the future, as you may just be making it more complicated down the road. So what is a transfer? Not every time money leaves your account, that doesn't mean in the future a Medicaid caseworker will penalize you for it. Basically, a transfer is when either the applicant or the applicant's spouse has made a transfer during the applicable look back period, whether it's 2.5 years for community Medicaid or 5 years for nursing home Medicaid, and that transfer was not exempt. So if you do things like, pay for your dental work, that's not a problem because that's something that directly benefits you. Other gifts, though, can really be an issue and really cause a wrinkle in your Medicaid eligibility. So like I was just touching on, the good news is that not all transfers are created equally. One of the main eligibility tools, one of the biggest benefits that we have as practitioners is a lot of our clients are married and transfers between spouses are exempt. So regardless of whether an applicant is seeking nursing home care or community-based care, if they make transfers of their non-exempt resources to their spouse, Medicaid is not going to penalize them for making that transfer, even if that transfer was a significant amount of money, and even if that transfer took place the day before you applied for Medicaid. There are also certain transfers of your home that are exempt. There are also transfers to certain types of trusts that are exempt, but those transfers are really fact specific. So I just wanted to touch on them just so you're aware of some other exemptions that do exist. So a lot of the gray areas, or a lot of where there's some confusion, is it remains really unclear how the home care penalties are going to be assessed. When someone's in a nursing home, we know exactly what that care costs because they're living there for 30 days or 31 days of the month. There's a set daily rate for their care, so it's very easy to calculate or figure out ahead of time what their penalty period will look like. When people are living in the community, however, care costs can vary greatly, largely dependent on how many hours a day of care they're receiving. So the New York State Bar Association has been pushing the Department of Health for some clarification so we could better advise clients about what the penalty period will look like. But we do know that once the penalty period will be going into effect, whether it's April 1st or July 1st or some other date this year, at that time, Medicaid will have come up with some calculation, some way that they can assess these penalties, and then we'll have hopefully a better idea or a better update for you at that time. But again, we do know that for people applying before the look-back period goes into effect, they're going to be assessed under the current rules and regulations, and there is no look-back period, which is obviously the much more straightforward way to get coverage. So I am done here. I'm going to check the chat box just to see if there's any questions here. So I have a question here from Nicole. It's a good one. So we don't know if so Nicole's asking, will the look-back period go into effect on October 1st, or when does it start? So what we do know is that transfers made after October 1st will be included in this look-back period. We just don't know when the actual look-back period will go into effect. So really what it means is if you made a transfer after October 1st, it could be an issue, but if you apply before the look-back period goes into effect, you won't have a penalty assessed, which is a good thing. So there's another question. Someone's asking, if you make a transfer tomorrow and are in need 10 years from now, will that be considered as part of the look back? So basically the look back period is really dependent on when you actually start needing care, not so much when the transfer is made. So if you make a transfer tomorrow and you don't need care for 10 years and you've made no other transfers, you won't have an issue because that transfer you made tomorrow won't fall within the look back period, unless Medicaid makes the look back period significantly longer, which nobody wants. I think that's it. So I'm going to turn it over to Nicole.
Teacher, there's one more question.
Oh, I didn't see that. Okay.
It says, can the RMD from an IRA be put into an irrevocable trust and be exempt?
So you don't want to do that. The more common way and the most straightforward way to place a required minimum distribution or to shelter it in some way is to deposit it into your pooled income trust each month if you're on community Medicaid. And the reason for that is Medicaid is going to assess that as part of your income. So really the only way to shelter it or protect it is to put it into a pooled income trust. And that way it's available for your care, it's available for your bills. If you put it into an irrevocable trust, really wouldn't be as flexible, wouldn't be as available to you to pay your bills on an ongoing basis. No, let's see. I think someone else just, so someone asked a question about Roth IRAs. So Roth IRAs are considered exempt so long as they're in payout status. So long as you start taking distributions from your Roth IRA, those could be considered exempt. Depending on the value of those accounts, some people find it more advantageous to cash them in before an application, but it's really very fact specific. But it's a good question. And then somebody else asked, if you make a transfer to a spouse, can the spouse then make transfers to children or others? So it's a good question. And again, very fact specific, but typically what happens is when we make these transfers to a spouse for the purposes of getting one spouse eligible for care, we wait till there has been a determination from Medicaid that the initial applicant has been approved, they're going to start getting care. And then we'll have the well spouse, the spouse that received all of these extra resources, come in and do some additional planning. So the short answer to your question is yes, but the more technical answer is you really should be coming in and not making any transfers until you've met with some practitioner that really knows the Medicaid rules and regulations, because you don't want to impact that second spouse's potential eligibility in the future also. And I think that's it. So I'll turn it over to Nicole.
So thank you, everyone. Thanks for your patience just there. Again, my name is Nicole Christensen. I'm the president of Care Answered. We provide patient advocacy and care coordination, helping people navigate through the healthcare system and keeping them calm and getting healthcare done. So today I'm going to be talking about Medicaid, specifically community Medicaid, and what we have now as far as care and eligibility, and what is proposed for the future. So let's start with now. As Deidre spoke to us about what's happening financially now and then what's happening in the future, whether that happens April 1st or July 1st, I'm going to talk about the same things as far as medical eligibility. So right now, to be medically eligible for community Medicaid, the general rule is that you need 120 days assistance with activities of daily living to enroll into managed long-term care. You have a Maximus evaluation, which Deidre mentioned, which is the state evaluation, and they determine whether you are eligible medically. Then one selects a managed long-term care plan, which there are many, and they do a nurse evaluation as well. And they tell you how many hours of care per day, per week that they will provide. Again, this process could change as soon as April 1st. So let's talk a little bit about the activities of daily living. So as of the 1st or July 1st or whenever it actually takes place, because there's not actually any information as to how they're going to make these changes yet. So there are likely to be many changes in this regard. But as of April 1st, according to the state, they're going to look at the activities of daily living, including ambulating or walking, personal hygiene, dressing, eating, bathing, transferring on and off the toilet and toilet use, and turning and positioning in bed. So the big thing that they're requiring with these ADLs are physical maneuvering with at least 3 of these ADLs for those that do not have a diagnosis of dementia. For those who do have a diagnosis of dementia, there's going to be a minimum of supervision for at least 2 of these activities of daily living. So I'm going to explain that a little bit further. So, for example, walking or ambulating. So if I do not have a diagnosis of dementia, what that means, that physical maneuvering means, I need somebody to assist me, physically assist me, a person, to be able to walk. So if my mom has the ability to walk, but now utilizes a walker, but doesn't need somebody physically touching her, assisting her doing that, that would not be physical maneuvering. That's just the device that she's using. However, if my mom actually gets unsteady using the walker and she needs somebody to hold on to her waist or guide her by physically touching her and helping her maneuver, that would be physical maneuvering. So I say this to say, if a device is assisting you, this is general, if a device is assisting you, then that's not requiring physical maneuvering, okay? And again, use the same kind of example for somebody that has a diagnosis of dementia. They can use, potentially, say dad can use the walker, but sometimes he gets confused how to use a walker in general. So he needs supervision because somebody has to say, put your hands on the walker and now get up, and maybe they'll hold the walker to steady him. So that might be more of supervision. But again, if they have a diagnosis of dementia, that would count as an ADL to make them eligible. So what in this new list is not included that currently is taken into consideration is incontinence, right? So they don't mention incontinence. They're only talking about toileting. So it doesn't specifically include incontinence after these new changes take effect. Transfers other than toilet use. So generally, if you need help, physical help transferring off of a toilet, you likely need that same kind of assistance getting up out of any chair or sitting down, or going from sitting to standing. So that's not specifically included. Medication administration is also not specifically included. In addition, in these new rules, the IADLs, what's instrumental activities of daily living, which include managing finances, handling transportation, etc. But one of the key things that won't be included is the housework, the laundry, the managing of medication, those kinds of things. So as it is written now, those will not be included within eligibility. And I know that there are some folks, certainly those that I've advocated for, that was a huge factor, that they couldn't cook for themselves, that they couldn't clean their home, which of course definitely affects somebody's physical capabilities and can harm their health. So that's apparently not going to be looked at anymore, which is a shame. So now let's talk a little bit about the changes to the process and the assessment. So right now, the assessment is done via the state maximus. So that's going to stay in place. Then the assessment is going to be also done or looked at by an independent doctor who potentially, because it's not very clear yet, would determine the hours. This is of concern as an advocate for any client or any person eligible for community Medicaid, because their regular doctor is taken out of the process. So this is a doctor that only knows the person on paper. The other thing that is of concern is if the hours are more than 12, meaning more than 12 hours needed per day, they're referred to an independent panel who then will determine if it's safe for the person to remain in the community. So a lot of my advocacy in regard to community Medicaid are for folks that need a lot of care. And so I am able to advocate effectively for things like 24-hour live-in or a split shift, meaning 12 hours a day and then another 12 hours, two different people providing that care, because there's not sleep involved, there's constant care needs. So who is it that's going to then determine and say, okay, well, you need live-in care, therefore we determined that it's unsafe for you to be at home. That's concerning for many, many reasons. And as all of you may know, somebody, or you are that person, that does not want to go into a long-term care facility, no matter what. And so what will they do? Will they say, okay, it's unsafe for you to stay at home? They can't force somebody to be in a nursing home or long-term care facility. So again, what will that mean to say it's unsafe for us to provide more than 12 hours of care, therefore we provide no care? It's very unclear, and really the wording of it right now anyway, it's concerning because it seems to step on human rights. The assessments that are generally done every 6 months by the nurse, currently by the managed long-term care company, apparently those kinds of assessments will be done annually rather than every 6 months, which again is a little bit of a concern because things happen. I don't think they're going to change the notion that you can always request another assessment if there's a health decline or a hospitalization. But the 6 month check-in, I think, is also just appropriate for people that need these kinds of services. Okay, so what are the other changes? Again, the state is creating an assessment system that takes managed long-term care companies out of the process of determining the number of hours of care, sorry. That was supposed to start April, and that was supposed to be after the financial changes. So again, that was the prospective date. I don't know when this will all occur. Primary care physicians, again, as I mentioned, will be out of the process of prescribing PCS or CDPAP, and it all may be done by an independent doctor who, again, may not have full understanding of the patient. Again, it was projected, this part of it was projected to start October of 2022. I don't know when this will start. Again, I don't think that they know either. The protocols and procedures for all of this have not been clearly stated as of yet. So, and there seems to be a push towards dual eligibility programs, which means one is eligible for both Medicaid and Medicare. There's a PACE program, which is a medical adult daycare provider where all services are on site, managed by an insurance provider. Obviously, we're in the middle of a pandemic. I'm sure none of the PACE services are really in there being utilized to their full extent because of it. The other program, which is a dual eligibility, is MAP, which is the Medicare Advantage Plus. So they have basically a Medicare Advantage plan with home care using only providers that take that insurance carrier. There's nothing really wrong with either of those programs, but a lot of my clients don't find them to be particularly effective. And the reason why for PACE is many people are just not interested in staying all day in adult daycare and being seen there. It can be very convenient for some people, but it's not for everybody, like most everything else. And the MAP program, the difficulties that many of my clients have seen with it is that they weren't able to keep their same doctors. So therefore they weren't interested in utilizing the MAP program. But there's definite there's a desire to limit MLTCs. They're not allowing, the state's not allowing new MLTCs into the market as well. So other changes as well is the Consumer-Directed Personal Assistance Program. Let me go back. That was the CDPAP that I had mentioned earlier. So the CDPAP is when you can get potentially a loved one, family, friend to provide the care, the home health aid care within the home. And then either the person themselves is the supervisor of that care, or a loved one is a supervisor of that care. So what that means is that that person is then, by supervising, they have to, make sure that they have enough aides for the care coverage. So it works really effectively for some clients, for some families. However, again, subject to change of date, but April 1st, the managed long-term care plans or any other portion of this system is no longer going to be required to inform people that CDPAP exists. That doesn't mean it doesn't exist. It just means that you won't be informed. Also, another change that did already happen is the managed long-term care lockdown. starting 12/1/2020. So it used to be if you selected a managed long-term care provider and it wasn't going your way, you weren't happy with the services, you could switch to a different managed long-term care provider. Obviously, there would be an assessment and that kind of thing, but you had the capability of switching. So now the change is, I guess, starting March 1st, if you've had the same MLTC since December 1st, you can change within this first 90 days. So up to March 1st. After that, you can only change your managed long-term care for good cause. And that good cause, I believe is they're going to make it so that it's a very good cause in their minds, meaning not that they didn't give you the right hours, but they've done something very poorly. So that's a change. And then, but you can transfer from a PACE or a MAP program. So that will still exist. Again, the steps I suggest to everyone who will listen is to apply. If you're on the fence, really now is the time to talk to your lawyer, to find out what steps you should be taking and really get your questions answered, and how to plan appropriately. The other thing is the waiver program, which I won't go into great depths about, but the nursing home transitional waiver program, as well as the traumatic brain injury waiver programs, are not apparently going to be affected by these changes, the financial or the medical eligibility changes. And so, yeah, talk to your attorney. You can always talk to us, an advocate, to access whatever care needs that you may have. And we, as well as the law group, will certainly be having updates as they happen. So I am going to look as well to see if there are any questions that are new. Feel free. I am looking in the Q&A and the chat. I don't see anything.
I don't see anything either. There was one or two that came in while you were talking, so I just answered them. But
okay.
I guess we'll hang out for another minute. If anyone has a question, please feel free to either put it in the chat or the Q&A box. I'm sure I speak for Nicole when I say if there's any more specific question that you don't want to ask here, feel free to reach out to us and we'll be happy to answer your questions. Unfortunately, not everything is 100% guaranteed answer because we're still waiting on a lot of direction and clarification from Medicaid. So we'll answer to the best of our ability.
Thank you, Sharon. Yes, absolutely. We're always here. So if you have any questions, feel free to give a call, email me. I will answer whatever questions I can. That's it.
I think that's it.
All right.
All right, everybody. Thanks for joining us.
Thank you, everyone. And thank you for having me, Deidre.
Oh, it was great. Thanks, Nicole. Take care, everybody.